We're on the record in cause number 323-892. The case is styled the state of Texas versus Derek W. Howard. We have, or Derek Wayne Howard. We have Mr. Howard, who's in court. Is that your correct name, sir?
Yes, sir.
And Mr. Howard is present with his attorney, Mr. Jack Lawrence. The state is present with his assistant district attorney, Mr. Raymond Shearer, Ms. Julie Maxey, and Ms. Ashley Ramos. Now, the state has several motions here, and just for the record, the court heard some of these motions in the past, and it was a motion to quash alternative, lead to set aside the information that was heard, a defendant's motion for quantitative weight analysis of alleged synthetic marijuana subsequent to removal of non-germinable seeds, contaminants, and material stalks. Motion to have BPD arrest videotape transcribed. Okay. And now with regards to these next motions, I put them in, I guess, three categories. And I guess the first category that I have is what we call motions that is actually usually heard on the day of trial. Okay, for example, Mr. Lawrence filed a motion to permit each member of the jury to have a copy of the court's written instructions during the deliberations. That's some, I guess that motion would be actually after the close of, I guess right before the jury get the case. He's asking for them to get, I guess, 6 different charges. Well, 6, the same charge, but copied 6 times. Is that correct? That's the court's instruction.
I'm not sure what you're talking about.
It's a motion to permit each member of the jury to have a copy of the court's written instructions
Yes.
during deliberations. That's what it's titled.
And that's an assumption that there are going to be 6 different jurors, and so each one of them has a copy of the court's instructions.
Well,
That's what that's for. And that is, I can't ask for that.
a state.
The state, for lack of a better expression, could really care less about something like that. That's just a matter of how much paperwork do we want to give them.
But normally we just have one charge that goes in that
And I understand that's customary, but the state is not opposed to making copies.
Your Honor, have we even announced that this is a jury trial in this case? I know we've been here several times, we've been hearing motions, but has it been announced that this will be set for a jury trial?
Mr. Lawrence?
If, I've been assuming the state would probably ask for a jury trial. As far as I'm concerned, I would just as soon have the judge do the trial, but actually that's up to the defendant. And I think we would be,
Well, you would have,
in light of his parole, I think he would be safer if the judge did the trial rather than the jury, but that's up to him.
And Your Honor, what I was getting at was if he's not even sure if it's going to be a jury trial, then it's not even timely to have these motions about the juries be filed because we haven't even announced it to be a jury trial.
okay. Okay, Mr. Lawrence, okay. That's, and so at this time, this motion to permit each member of the jury to have a copy, that's gonna be, we're not gonna hear that now.
Yes.
Okay, then there's another motion. actually, look at this here motion here. You have a motion titled Defendant's Combination Trial Motion,
Oh, yes.
and that would, I guess, fall in the same category of the previous motion that we don't know whether or not it's gonna be a trial. Here, you asking, your combination motion, you asking for the judge to, you electing the judge to set punishment, and you want an arraignment outside the presence of the jury, if I'm not mistaken. And then also in here, you have you want the court reporter to record all proceedings. The court reporter records all proceedings.
Yes.
So in reference to your election to punishment, that's not sworn. This is just a motion.
It requests the judge to assess punishment, that one does.
Okay, but the question is whether or not, you're just saying it's the judge will set punishment if it's a jury trial, right?
Yes,
Yeah, but so that's why I said that it probably falls in the same category of this,
it does.
this previous motion where you're asking for me, permit each member of the jury to have a copy, because at this time you have not announced to the court as to whether or not you want a jury trial or not.
Yes, it does, and that's the defendant's choice, Your Honor, but
I understand.
when I did that motion, I assumed that normally in Jefferson County, the state does request a jury, so that's a built-in assumption that I should not have made. And so, if they don't object to the judge trying the case, I certainly.
Well, you would have to submit your proper motion to do that.
Mhm.
Okay,
It's
I mean,
up to the defendant if he wants the judge to try.
yeah, I
the
mean, I
case.
don't think you can, you making an oral statement, but I think you need to present the proper motion. If you electing, whatever your election is, if you decide to go to trial or not, I don't know. But at this time, it seems like you don't know whether or not you hadn't made a decision, or your client haven't made a decision as to whether or not it's gonna be a plea or a trial at this point. So at this time, we won't hear this motion at this time.
Just to clarify slightly, because the quantity is so small, well, Pam French had actually approached me about.
Oh, no, Mr.
I'm not
Lawrence.
gonna go into it.
No, I was only asking you about this combination motion and nothing else. We'll get to other matters later on.
All right, yeah, I was just gonna say that, if for any reason this might become a Class C, that, my client and I would have to discuss it. He might prefer that.
Okay,
to a
well,
trial. He might prefer that to a trial. I
so
don't-
right now, you don't know whether or not you want a trial or not. Is that?
That is actually correct.
Okay, so I'm not gonna, hear this motion
That's
at this
correct.
time. Okay?
Yes, Your Honor.
Okay. Okay, and this is another motion that falls into that same category. Defendant's motion for the disclosure of matter used before the jury or used before the judge or used to refresh memory. So apparently, this falls into that same category.
Same.
Okay. Okay. Oh, and then this one falls, you say a motion to invoke the rule prior to voir dire. That falls into the same category as well.
Yes.
Okay. Okay. This is the same thing, invoke the rule. Okay. And this next motion to submit attached jury questions to the jury and receive responses at least one day before. That falls in the same category because this relates to a jury. Is that correct, Mr. Lawrence?
Yes, it is, Your Honor. Yes, it is. And
Okay,
you'll notice that is a standard jury question.
okay. Now, And this other motion, and you say you have a motion requiring the state to make an opening statement. That's what you titled it.
That is new law, Your Honor, and I was delighted to see it.
Okay, so this is also a jury question.
Yes,
Okay. Okay. You have another, well, you have a motion here to withdraw as counsel of record.
we had discussed that one some time back, and you had asked me to stay on.
I didn't ask you to stay on. We never heard the motion. I mean, I think
Yes, sir.
you filed this motion. And so my question is, do you want to, are you proceeding, I mean, are you going to go forward on this motion, or are you withdrawing the motion?
Well, actually, my client prefers the attorney who had in the past been the judge in this court. I can't think of his name right now.
Judge Corey Crenshaw?
No, not him.
Judge Flores is not living.
Yes, the tall gentleman.
Judge
Langston
Plus-
Adams?
Hmm?
Langston Adams.
He wasn't judging
He
this
wasn't
court.
a judge in this court, but when he said a tall guy.
Okay.
No,
believe
well,
that
this
was-
gentleman was the judge of either this court or court number 2. I can't remember.
Yeah, but
Or court number 3, I mean. It's not Winston Adams. This
Your
is a-
client is nodding yes that it's Langston Adams.
Langston, yes, Langston. Not, I mistook you to say Winston. Yes, Langston Adams.
well, I think
He prefers-
you put that in this motion, but as you're aware, court appointments are not made on the preferences of the defendant.
Yes.
Court appointments are made on we have a list of attorneys, and that we go down that list. Okay,
Yes,
that's how you got appointed.
Your Honor, actually, not only had my client signed that motion, but Langston Adams also signed.
But that does not, a lawyer saying he wants to be on a case doesn't override the article where we have appointments here. Appointments are based on who's next on the list. Thank God. And so you can't say who you want to have as your lawyer.
Just for the record, Your Honor, I'll state that and Mr. Adams, I know I've discussed it with him, he would still want to take the case because he knows the
Okay.
gentleman.
Yeah,
But if that was to transpire, I would be glad to step aside and let Langston.
but that's
Adams-
not going to transpire.
Yes, okay.
So, I mean, this motion is denied. Motions to withdraw and pick who your lawyer is gonna be, it doesn't work like that.
That's fine.
In fact, I think you are familiar with, is that 115? Where is it? Is it 1? 215.
Your Honor,
Yes,
at this time, could we take a very brief recess? Because the opposing counsel mentioned something more that I'd like to explore closer with them.
with him?
It would be something to be considered
Possible.
negotiations and.
Oh.
and If Your Honor, if you're.
Okay,
with
I mean, if,
recess.
Mr. Lawrence, the
That's
state, states that they would like to, I guess, further negotiate
Yes, Your Honor.
prior to proceeding on your motions?
Yes, that's fine.
Okay. Okay. Okay, hold on a minute, just for the, let me get this. Yeah, now, basically what I was saying, that those rules pertaining to the appointment of attorneys is found in Article 1.051 of the Texas Code of Criminal Procedure. Okay. We'll be in recess to give y'all an opportunity to talk. Would y'all like to talk here or in the room?
Talk here real quick.
Yes.
And